docket. That is case number 106689, State of Kansas v. Delbert McBroom.
Morning, Chief Justice. I would like to reserve 3 minutes. My name is Gerald E. Wells. I'm from Lawrence, and I represent the appellant in this matter.
3 minutes is granted.
Thank you. I've tried to be as thorough as possible in argument regarding the denial of the change of venue by the trial court. In fact, I spent a number of pages outlining in detail our argument, but I do want to emphasize a couple of things about that particular issue and then move on to the insufficiency of the evidence issue. In its brief, the state has cited 3 cases wherein they use that to support the theory that in those cases there was a question of change of venue, and there was a survey used in those particular cases. There were, in those surveys, they also, like this case, had a high degree of percentage that the defendant would not get a fair trial in that venue.
A survey by the same individual?
Yes, as a matter of fact, Judge, that's correct, Dr. Biesiger. However, those cases are distinguishable, and they're distinguishable because in each of those cases there was overwhelming evidence against the defendant in the form of DNA evidence, in the form of eyewitness evidence, which is obviously not the case here.
So if there's overwhelming evidence, then you're not entitled to a fair trial.
Well, in terms of whether or not the motion should have been sustained, I think it's relevant because that judge sitting there, he went through the preliminary hearing, he had to know that that evidence was razor thin if it existed at all.
No, a preliminary hearing, many times a prosecutor will just present a bare bones case to get probable cause and move on. You
Correct.
Don't present your whole case at a preliminary hearing. So what you're suggesting is a part of the calculus in a change of venue hearing is the nature of the evidence, though the overwhelming nature.
I'm sorry.
I'm having trouble seeing that even enters into the calculation, but that's your argument.
Isn't that more of a prejudice analysis?
I'm sorry.
That's more of a prejudice analysis, isn't it?
Yes, I think that's true, and that was my point. The other point I want to emphasize is that Dr. Biesiger made a rather large point in his analysis of all of that data, that this was a case where the majority of what the people learned about that case was on a person-to-person basis versus newspaper, for example. It's a small county, and one could expect that. They also knew, and I think this is his point, that Kenneth Wilson, the shooter in this case, had his trial before this case, before Delbert McBroom, and he was convicted, and there was substantial evidence that, in fact, there was a large percentage of people who knew there were 2 people involved. And I think that makes a difference because guilt by association, which I want to take up on the insufficient evidence issue, I think should have made a difference.
Are you agreeing that the evidence establishes that there were 2 people involved?
I don't know what the evidence established. I know his name was mentioned in Kenneth Wilson's trial, and I don't know to what extent. But the point is, people assumed that and knew about it and were aware of the fact that Mr. McBroom came up in that trial. Now, moving on to the insufficient evidence, which arguably I think is the most important and perhaps the fulcrum of my argument. I think going forward on the insufficient evidence issue, I think I want to emphasize that there's a constant thread through this case. And that was that there was a co-defendant convicted in this case. Kenneth Wilson was convicted as the shooter in this horrible crime of Mr. Knoll. Secondly, and I think this is of substantial importance, Mr. McBroom, throughout this trial, maintained his innocence, even through sentencing, when arguably it could have done him a lot of good on the consecutive versus concurrent sentencing. So this wasn't a case where he gave up on that innocence after he was convicted. He maintained that innocence, and I think that's important for this court to consider.
That's a factor to consider, whether there's sufficient evidence, is that he claims he didn't do it?
Well, I think so, Judge, because
If he claimed he did it, that's going to...
He could have said on sentencing, he could have said, I didn't do this, which is exactly what he said, or he could have said, well, okay, I give up. I'm going to make this argument on sentencing because it might do me some good versus concurrent and consecutive sentencing. Now, what evidence did the state proffer in this case? First of all, it's important to know what they didn't have by way of evidence. They had no confession, no eyewitness, no DNA, no scientific evidence at all, despite the fact that the KBI was crawling all over that crime scene, taking DNA samples, none of which showed that Mr. McBroom was in that vicinity.
Our Kansas case books are full of cases that have scenarios where the defendant is not proven necessarily to, or there's no evidence, direct evidence tying him or her to the scene of the crime.
Of course.
That's based on you prosecuted cases like that when you were a prosecutor, where even the body hasn't been found, or where there's evidence that doesn't tie directly the perpetrator to the victim at the time of the crime, but is maintained by circumstantial evidence. That's the whole case. Plethora of cases like that. What's different about those and this case?
Well, the difference is that circumstantial evidence, by definition, has to be a reasonable inference from a fact. Now, in this case, they couldn't even show by any evidence that he was in Osborne County, much less at this crime scene. There's no evidence to that fact, circumstantial or otherwise. There was no fingerprints.
Could I clarify on the state has made a point of the fact that defendant said he was with Wilson all day on March 25th, which was the date of the murder. Wasn't his statement that he was with Wilson all day in Missouri?
Yes.
Okay, so when they say that he admitted to being with Wilson, that doesn't place him in Osborne County, does it?
Places him in Missouri.
Well, it places Wilson in
Yes.
Osborne County.
Wilson.
And he says he's with Wilson all day. So isn't that an inference he's in Osborne County? Because Wilson was in Osborne
Well,
County.
didn't he testify that they were in Missouri? That's what he said.
Yes.
Okay.
That's the testimony. But I think it's still not circumstantial evidence that places him in the house with the intent to kill and rob this individual. Now, beyond that, it's not a question even that all of the evidence was circumstantial, which it can be, but there was direct evidence from state's witnesses that those witnesses that they placed on the stand, particularly Brad Davis, who sees the car coming out of the crime scene, and there's one person. There are several other witnesses that were in a position to see that car, all of whom identified the car. who's connected to Kenneth Wilson. But they could not identify Delbert McBroom as being in that car.
Benson said he saw a passenger.
He saw a passenger, but he didn't identify that as McBroom. And he got close enough to identify his hair and his glasses and that kind of thing. So the point is that the most relevant evidence, to put it that way, of what could have been an association of McBroom with the crime scene is Brad Davis pulling out of that farmhouse. And nobody's with him. Kenneth Wilson is the shooter. Delbert McBroom wasn't in there. Now, to counter that evidence, the state, in their theory, alleges that, well, it's a reasonable inference that there was one occupant in the car in the house, and he was doing the robbing, and the car pulled out without him, and the car came back. There's no basis for that kind of reasonable inference. No basis for it. But that's the best they could do in countering their direct evidence.
How do you factor in the jury's considering all the evidence that the state put forth, the evidence that the defendant put forth, the argument that you're presenting right now was probably made to the jury in much the same fashion, and they found all the elements of first-degree murder were met beyond a reasonable doubt.
Based on what? Insufficient evidence? There's no evidence other than his association with Kenneth Wilson. In fact, if you look at instruction number 14, the court deliberately tells that jury, guilt by association, I'm paraphrasing here, guilt by association is not enough. You've got to show that he was at the crime scene and that he participated in that crime. So they were on notice, the jury was on notice, that
Mr.
it
Wells,
had to be more than that.
excuse me.
Yes.
I'm sorry to interrupt. Was there evidence about the appearance of your client at the time of these crimes? Did he match the description of the passenger?
No,
Okay.
it did not. In fact, the opposite. Whoever was connected by the witnesses that, in some cases, look an eye to eye,
There was-
described Kenneth Wilson. Never, and
I'm just trying to focus on the one person who said he saw a passenger in the car.
Yes.
And the stringy hair and the glasses. That did not describe your...
he did not identify. In fact, KBI agent Howell admits on cross-examination that none of the witnesses identified Delbert McBroom.
And there was also a woman, and I want to say it was Mrs. Hagenhanser, that saw someone, and it was in the same time period, driving up to her house.
It was
She
a different location,
stopped
Judge.
and talked to them, but nearby.
Mm-hmm.
And did she identify that as either Wilson or?
Identifies the person as Wilson, not McBroom.
And there was only one person in the car.
If I recall correctly, that's true.
Any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. Do you need my bar number? Because I'm not. It's 23156 if you do need it.
Just a little bit.
Oh, I'm sorry.
Could you just speak
Oh,
up
yes,
just a little bit?
absolutely.
Thank you.
Regarding the change of venue, there are 3 points the state wishes to make. First, there is no evidence that there was any difficulty picking a jury in this case. The jury selection only took 1 day. Only 8 jurors were challenged for cause, none of which sat on the jury. Only 49 potential jurors were questioned before they were able to pick a jury. Second, there's no indication that the jury was biased in this case. They all took an oath, they were all passed for cause, and the survey doesn't determine if the jurors can set aside any preconceived notions of guilt. It doesn't determine whether or not they can follow their oath to hold the state to its beyond a reasonable doubt burden. Thus, the third and final point is that the court did not abuse its discretion in this case, and that is shown through Higginbottom and those other cases where it was the same surveyor and there was no abuse of discretion.
What would it take for a court to abuse its discretion in denying a motion for change of venue?
I think if there was evidence of a real struggle of the ability to find jurors, that would be something with
So
this court.
any motion prior to jury selection wouldn't suffice in your mind? You'd actually have to begin the jury selection process in order to determine that, hey, we can't.
Well, that's the only way to determine prejudice. That's the only way to determine if the court did abuse its discretion. Pre-trial, the judge, it's entirely in his discretion whether or not the survey is enough, or his or her. It's up to him, and there's nothing the state can do one way or the other. But the only way to show prejudice is to look at the actual jury selection.
Discretion is not supposed to be completely bulletproof, though.
True.
I mean, that's what we're trying to get at. It seems to me that these arguments are kind of ships in the night. Because if people are really committed to a position that someone is guilty, then are they likely to say that they can say honestly in response to questions during voir dire that they can't set that aside? I mean, I just think that to a certain extent it doesn't meet the objection that arises out of the survey. Do you see what I'm getting at? I mean, you're talking about two different points in time, different motivations.
Right. I mean, yes.
People have a motivation, perhaps, when they're sitting there in the jury box.
Most of the time to get off the jury, but
Yeah,
for those that want to sit,
And if they're committed to a position on guilt already, then they may want to. That's what I'm getting at. It seems to me that they don't really answer, that what you're proposing would be the things we look at don't really answer the concern that arises out of a survey.
but we presume that a jury will follow its oath, and they took an oath to consider the evidence, to hold the state to its burden of proof, and to presume that the defendant is innocent. Did you have a question, Justice Ness?
I'm just going to ask, what about a possible consideration that in a community and county of this small size, there are some people who would like to serve on the jury? It's not everybody who wants
That's
to get
true.
off jury duty.
Absolutely true. I would love to be on a jury. Will never happen. But still, the jurors took an oath here. They all said that they could be fair and impartial. There is no reason to believe that they were lying.
You
Sure.
said there were 9 challenges for cause.
I believe 8,
Okay. How many were granted?
5. And none of the other 3 sat.
The reason I ask is often the judge also controls that aspect. At some point when challenges for cause are not granted routinely, then you shift emphasis to what you're going to do on peremptory. So it's not always a fair and accurate assessment when you simply look at number of challenges type of thing.
I can see that, but here there were at least 50-50 shot on granting.
Right. Okay.
My math is bad on 3 of you.
And I part of the problem I have is it seems like we get a lot that the Supreme Court's never done it. Never overruled a denial of change of venue, and I'm a little reluctant to use that as a basis just because it's never been done before. Because there is a statute that says you can do it,
Right.
that you can change it, and so it must mean something if it's there. Must mean that it's available to be used in the appropriate circumstance.
Absolutely. Turning to the sufficiency of the evidence, all the inferences in this case were justifiable. Here we have 2 trips.
Let me start, I want to start with the evidence that there were 2 people that committed this crime. All I saw you saying is that the victim was a strong man, so there must have been 2 people, and that his hands were bound, so there must have been someone to hold the shotgun while the other person bound their hands. Was there any other evidence that beyond speculation or guess, any other evidence that there were two people at that house?
There were two people seen leaving the house. On the Highway 241, what the witnesses have them, I had to do a little map because I'm not good with geography. The first witness that has them going west on 20th Street, then, or just Wilson is going west on 20th Street. Then the second witness sees Wilson come back towards the house, and then the third witness has them going north on 251. At that time, that's Jeffrey Benson, there are two people in the car. And that second person is the stringy hair and has the eyeglasses, which there is no evidence on the record that that did not fit the defendant's description. There could have been better evidence that it did fit the defendant's description.
Was there
but
any evidence that it fit in?
No,
Okay, so there was no evidence either way
either way. The jury would have been able to look and see whether or not that did fit him.
at that point, but I'm just talking about at that point in
Right.
time. You know, frequently defendants' appearances change.
They clean up a little, yeah. The inferences that they robbed together is based on the fact that in the earlier, from the March, I think I'm going to say 13th timeframe, property was found in in McBroom's RV and in Wilson's house from one property. So they robbed together before. Coincidentally, their trips that they take together end up with these robberies. McBroom admits that he was with Wilson the entire time. We know Wilson was in Osborne County because his DNA evidence is found on the cigarette.
That's a little disingenuous. When he says, I was with Wilson all day and we were in Missouri, that's not admitting he was with Wilson in Osborne County. Now, you can impeach that and say it couldn't have been true because Wilson was in Osborne County, but that's not an admission that he was in Osborne County.
No, it's not an admission he was in Osborne County. It's an admission he was with Wilson, and Wilson was in Osborne County.
Here's what I went through and made a list, and I want you to tell me if there's more that you're relying on for the evidence of guilt. Mm-hmm. One, that the defendant was close friends with Kenneth Wilson, who was convicted of this murder. Two, there was some property from other burglaries that were found in defendant's RV that was parked on Wilson's property. Three, that defendant made inconsistent statements about where he was on the date of the murder. Four, that there was burglary of the Clark house, suggested a two-person job because of the different styles of searching. You had disarray versus the neat thief. Fifth, you say Wilson's wife puts the defendant with Wilson during the time period. Sixth, the eyewitness saw only one person in Wilson's car, so we can logically infer that the defendant was inside the victim's house. Seven, the victim is a big, strong man, needed two burglars to overcome. There was evidence of premeditation. Eyewitness Benson placed two people in the car, and DNA linked to Wilson to the murder. Is there any other evidence
I think the only other
that you
thing
rely on?
that we had was that the defendant was living in an RV on Wilson's property and had unfettered access to the Wilson's home. So just because the property mostly was found in the Wilson home, McBroom could have easily put it there.
Wasn't there evidence also about a rifle that was found in one of the burglaries that was kept unloaded and was found loaded?
Yes.
This rifle also was
loaded.
kept unloaded and found loaded that
Yes.
ultimately was the murder weapon.
Yes, and those two series are connected.
The theory is that McBroom and Wilson were involved in the prior burglary where that
Yes.
conduct took place. And
How was that tied to McBroom rather than Wilson on the rifle? I mean, we know Wilson was convicted.
Right.
So we know that. So, I mean, how was the rifle evidence, how did it bring McBroom into the calculus?
Again, they took the two trips together. They were with each other the entire time. And the first time they took trips together, we know McBroom was present because there was property found in his RV from one of those robberies. During one of those robberies,
Well, that's not an absolute.
right.
I mean, he could have purchased the property or been given the property afterward. Okay, go ahead, sorry.
We can infer
Just
that
don't want
Wilson
to,
was,
yeah,
right.
you could draw an inference.
Inference that McBroom was there. Also during those robberies was the same mechanism was used where if there was a shotgun or some kind of weapon, they took that out first, they loaded it in case anyone came home, and then you come back. In this case, someone came home. And so the fact that they're on these trips together, they're tied together.
The fact is, okay, the facts in what you've just said, the facts are that there's property in McBroom's RV, and that at another burglary, there was a weapon that was normally kept unloaded that was loaded and found on the scene. And from that, you're drawing your inferences that, number one, McBroom was at the burglary where the other rifle was, and therefore he was also at the Knoll house.
Yes, the two burglaries were both on the March 12th, the same day, located near each other. The one that property was found in the Wilson home, or so McBroom's RV and in the Wilson home.
Could you explain to me, it's always been a very fine line between what is commonly called inference stacking versus what is circumstantial evidence that supports evidence in the case that supplies the evidence for conviction. What's the distinction? And can you point it out to me in this case?
I think the 10th Circuit did a good job of saying it has to be a justifiable inference. You can't reach out and grab some. At some point, yes, the link is too tenuous. It's
Right.
too circumstantial. In this case, the only question here is identity.
Sorry, say that again?
In this case, the only question is identity. Was McBroom involved? They're not contesting that there was all the other elements were met. It's just identity. So we only have to get one inference, and that's that he was there.
So you would rely on the 10th Circuit case to give us guidance in analyzing whether this is inference on an inference or whether this is circumstantial
Legally,
evidence.
yes.
Yeah. Okay.
The way I understood it, the impermissible stacking would be, for instance, in this case, the fact is that the victim was a big, strong man. From that, you infer that it would take two people to rob him or subdue him, and from that fact that there must have been two people, you add the second fact that McBroom is a friend of Wilson, so therefore we infer that McBroom is the second person. So you're starting with this one fact, and then you're making multiple inferences to get to where you want to be.
Or we can make the inference that they were together, they robbed together before, they robbed together here. We can get there faster. The rest is just more circumstantial evidence that he was indeed present.
But the only way you get evidence that they robbed before is because he's in possession of stolen property.
Yes.
And so from that, you're getting the inference that they've robbed before, as opposed to he's just in possession of stolen. Because they live on the same property, he happened to have property that Wilson had stolen.
Yes.
Okay.
Well, and that's the stacking. From the stolen property, you infer that they were together and committed that particular burglary from which the property came. And from that, then you infer that they were also burglarizing together on this date. And from that, you infer that he was participating in.
And I don't think the rule precludes multiple inferences being drawn for multiple different reasons. It just, the inferences have to be justifiable, and here they are.
I think that's where the stacking part comes in.
Yes.
If it's kind of a vertical inference, series of inferences as opposed to multiple inferences from various pieces of circumstantial evidence. I think it's a vertical versus horizontal problem.
Yeah, and
Does that
here
make
I
sense
think
to you?
there are, yes, absolutely. I think
Okay,
there are
so-
vertical inferences. It's not,
Here
horizontal,
you think
not
they're
all vertical.
horizontal, and what's been suggested is that if you're inferring from the presence of stolen property in his RV, that he burgled before with the guilty party, then you have to stack on top of that inference that he burgled on the day. So there's a suggestion that they're both vertical and horizontal going on here. I think it's what the suggestion's been from the bench.
But I think there are multiple different inferences. We have the fact that there are two people. We have that they're together on the trip. We have that they have robbed together before,
Right.
which is an inference.
There's certainly horizontal ones
Yes,
as
there
well.
are lots of different inferences, and I do think that they are horizontal, not impermissible stacking in this case. For that reason, I would ask that you affirm the district court and McBroom's convictions. Thank you.
Any further questions of counsel before she sits down? Thank you, counsel.
I would take issue with a couple of statements by the state. First of all, to infer that there were two people in there, you have to infer from what? The state has all kinds of forensic
Excuse me, you're talking about two people
Yes.
in the house of the victim? Is that what you're saying?
Yes,
Okay.
yes, Judge, I'm sorry, I wasn't clear. The KBI and the state has all kinds of resources, including forensic experts, that could have testified, well, this was the kind of situation where only two people or more could have accomplished this, but they didn't put that evidence on. This is purely conjecture on their part, and they failed to put on any expert evidence to the contrary. Now, had Mr. McBroom been in that house, no evidence that he was even in the county, why didn't they pick up fingerprints? Why didn't they pick up DNA? They didn't. There were ropes, there were weapons, there was all kinds of activity in this house, and it did not happen. Secondly, great reliance is made by the state upon these prior burglaries. If memory serves, KBI agent Howe testified that he was not convicted. Mr. McBroom was not convicted in any of those prior robberies. He was implicated but not convicted. Now, I haven't looked at the transcripts of that, so I can't be 100% sure, but I believe
Was he
that's what-
charged?
Pardon me?
Was he charged?
You know, I don't know, Judge.
Well,
I can't remember.
Might be why he wasn't convicted.
Could have been. But in any event, there's simply no direct or circumstantial evidence. There has to be a reasonable inference, despite what the 10th Circuit says. There's got to be a reasonable inference from a known fact to infer that Delvin McBroom committed this crime. And going to Justice Byers' point, how many times have people in this room that have tried criminal cases, including myself, have had prospective jurors say, I can be totally impartial. Yeah, I knew the guy. I can be totally impartial, though. And that lasts about until the first autopsy pictures are shown. Then all of a sudden, it's a whole different attitude. And I've seen it personally, and others may have seen that as well. So the fact that you had a juror on this case that had hunted with and was friends with the deceased here ought to be taken into account. But my main point is this. This man is going to serve consecutive sentences, life sentence plus the burglary and the ag robbery and the other burglary, I believe it was. He could die in prison based on the flimsiest evidence that has to be inferred to the point of nonsense, that he was even the house, he took part in this crime in any way whatsoever. If he had possession of stolen items, why didn't they charge him? Why didn't they charge him with possession of stolen property? They didn't.
What do you, excuse me, counsel, what do you
Sure.
do with the testimony from the wife that Wilson and the defendant went out to western Kansas during this time frame? I mean, you've got that, and then you've got the stolen property, and
But
all I'm wrestling with is why isn't this in the light most favorable to the state? Or if I'm the trial court and I'm trying to decide whether this case goes to the jury, why isn't that enough and this is what juries do?
I'm not sure I can answer that question directly, but I will tell you.
Talk to me about the wife's testimony. That was my springboard.
Right. Miss Wilson said that they did take a lot of trips together. Mrs. McBroom added to that by saying sometimes they took different cars. They did go to western Kansas looking for employment. The important point there is there's no evidence to the contrary. Now, he changed his story. But the state says he lied. He made additions to his story. Sometimes they were different. But that doesn't mean it was a lie, and that does not put him in Osborne County. There was come and go as you please at the Wilson property from the RV to the house. But where do you leap from the fact that they were together putting McBroom in the house beyond a reasonable doubt? I would suggest to you that despite what Miss Wilson says, which admittedly she says they're together all the time, but that doesn't say that they were in the house together. Now, further than that, Judge, I tell you this. At the preliminary hearing, McBroom had been charged with a conspiracy along with Kenneth Wilson. Now, as we all know, 99% of the time, you're bound over from a preliminary hearing. There's no question about it.
Is this in your brief anywhere?
Yes, it's pointed
preliminary
out in the facts. Yeah.
Right.
And that charge of conspiracy was dismissed. So what does that mean? I think it means that there's not a semblance of agreement, communication, knowledge of any kind, because all you have to put on is bare bones case on conspiracy, that there's an illegal agreement. And that goes to the fact that McBroom doesn't know anything about this. I urge you to find that there's insufficient evidence based on what the state has said, what the state put on, even given the best light to the state.
Thank you, counsel.
Thank you.
Do you have any further questions? Thank you both for your arguments this morning.